Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Thank you, Gio. Good morning to you all. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my left is Judge Tan, and to my right is Judge Smyth. We'll be your panel for the two cases that we have on our docket this morning. To the parties, I see some familiar faces. You know that we've read your materials, we're familiar with the cases, so you need not go extensively over the background unless you choose to. 15 minutes per side, no rebuttal. Time is yours to use as you see fit. First case on our docket is 24P0834, the Commonwealth versus Lorenzo Jones.
Good morning. May it please the Court, Christopher DeMeo for Lorenzo Jones. So there is a Guardado error in this case, and we now know from the Crowder case that Mr. Jones could be retried on the gun charge, notwithstanding the Guardado error. So the reason I'm here today is to talk about some other potential arguments for the Court's consideration that, in our view, would be more beneficial to Mr. Jones.
Say it again, please. The reason you're here today is leaving the Guardado issue aside.
Leaving the Guardado issue to the side, there are some other arguments that we have raised which, if successful, would, in my opinion, bar retrial. So I think there's still live issues, notwithstanding the concession of a Guardado error.
So I assume we're not talking about the jury instructions. You're talking about the sufficiency of the evidence and the stop?
I am talking about the jury instruction as well as sufficiency, because in my view, if the jury instruction was incorrect, the time to bring that charge has expired. So I think that would be beneficial to Mr. Jones. So I'll start with the jury issue since that was raised. So the issue here is the principle that the trial jury has to decide the guilt of the charge that was passed upon by the grand jury that they found probable cause for. And we'd submit that's not what happened in this case, and there's direct and indirect evidence that the charge, the gun possession charge that Mr. Jones was found guilty of was not the one in the contemplation of the grand jury. And I guess the indirect evidence is that both Mr. Jones and Mr. Evans were charged the same way, 2 counts of murder, 1 count of gun possession. Now, Mr. Evans, certainly, no one ever alleged that he had the gun during the car chase the next morning. So I think it's clear just from the way this was charged, what people were talking about was the shooting and the gun that was used at the time of the shooting.
But to frame the issue, excuse me, the indictment didn't specify a particular type of handgun, correct, or firearm?
I don't believe so.
And the bill of particulars didn't either, correct?
That is true. The bill of particulars said that the bill of particulars did narrow things down by saying it was the same gun and that he had it continuously from 2:43 a.m. at the time of the shooting until the time of the car chase, which was about 8 hours later, I guess. So it didn't specify it was a Glock or any particular model. But we have more than just the indirect evidence. We have
That gun that was recovered the following morning, that was the gun that was linked ballistically to the homicide?
That is true, yes, it was.
And when you say that they linked the gun continuously from 2:43 in the morning until the following morning, is that what it explicitly says, or they just say it's the same gun?
I can pull up the bill of particulars, but I believe it says continuously. I mean, it's clear. I think it's clear from the bill of particulars that because they say continuously, so he had it and he kept possessing it, so it would be the same gun. However, that's not what, and this is sort of the gist of it. That's not what the prosecutors said earlier in the case when they were trying to argue in the suppression motion that Mr. Jones didn't have standing. What they said there, and this is at page 87 of the record appendix, is that Jones has been indicted for possessing a firearm and 2 counts of first-degree murder at the time of the shooting deaths of Clarence McGregor and Tesia Montgomery, approximately 2:43 a.m. on January 27, 2014. And then they go on to say, so you don't have standing to argue about what happened during the chase because we never charged you. We didn't charge you with leaving the scene of property damage. We didn't charge you with anything relating to the chase, even though we think it was you. This case is all about the shooting. It's all about 2:43 a.m. So given our position is the Commonwealth is bound by that. That is a concession about how the case was presented to the grand jury, in addition to sort of the indirect evidence I just mentioned. And the Commonwealth's position seems to be, well, it doesn't matter. You can just look at the indictment, and the indictment is broad, but we submit that there is some meaning to that statement that the prosecutor made, and it was made both in writing and orally, so this wasn't a kind of off-the-cuff thing that somebody said without thinking about it. It was a strategic decision that the government made back in 2018. And it may well be that by the time this went to trial in 2023, the lawyers had changed and people may not have been thinking about this, but nonetheless, it's there.
There's no objection at trial, correct? So we're looking at it from a substantial risk of miscarriage
It
of
is,
justice
yeah.
standard?
It's a substantial risk. But our position is there's no conceivable strategic reason why you would want the indictment read broadly rather than the way that I just read here at 243. So I think the only really plausible reading of what happened is that everybody had bigger fish to fry. This was a first-degree murder case. They were thinking about first-degree murder. They weren't necessarily the lawyers who were present back at the suppression hearing 5 years earlier, and that's how it happened. But I would argue it is substantial risk because on these facts, we know Mr. Evans was charged exactly the same way, and he was acquitted across the board on all three because the jury for Mr. Evans was thinking about 243. They were thinking about the shooting, and had their attention been narrowed to 243 for Mr. Jones as well, I submit it would have been just like Mr. Evans. So he's sort of the control case here. So that's the gist of the substantial
Was Mr.
risk.
Evans' DNA found on the gun?
No, it wasn't. He was excluded, or I don't know if he was excluded, but
Jones's DNA was found on
Jones's DNA was found on the gun.
Okay.
In a mix of three people. And that kind of brings me to the,
It was found on the gun that they recovered the morning after the operator of the red Chevy had fled.
it was found the next, well, it was after they recovered.
Same morning, I say the next morning, later in the morning.
Yes. Right, so I mean, that's,
Your position that the Commonwealth's representation trumped the indictment? Is that your position?
I guess my position, I don't know that I'd say it trumps the indictment. I would say that it's a concession. There has to be a match between the indictment and what the grand jury decided and the charges that go to the trial jury.
So what did the indictment say? He possessed a gun on a certain day, right?
Yeah, he possessed the gun on the 27th, right. So
Isn't that true? Isn't that what?
that is true, and if that were all there was, then this wouldn't be an issue. But because of all the facts I've just mentioned, and if it were just the case that he were indicted the same as Tony Evans, then possibly that wouldn't be enough either, although that sort of strongly suggests to me that the focus was on 243. But because we have the statements I just read, I wouldn't say it's trumping the indictment. I'd say it's a concession from the Commonwealth that this is in fact how the case was presented to the grand jury. I didn't do this as a new trial motion. The grand jury minutes aren't before the court, but I think this is sufficient for estoppel purposes because, the trial judge shouldn't have they just know what's being represented to them by the prosecutor, and that's what he said, and I think that should be binding. It should have estoppel effect.
Could you address the motion to suppress issue?
Yes.
Since I know your time is...
Yes. So what's interesting about this motion to suppress issue, I think, is that you have two different judges deciding at different, approximately 5 years apart, and making credibility determinations, and yet it seems to me they're kind of in conflict. So Judge Donatel does not hear from the confidential informant, but she hears from the officer who talked to the informant.
So isn't she limited? Isn't the analysis of the motion to suppress limited to it has to be limited to the record, right? To the evidence that was taken at that hearing?
Yes.
And I know that defense counsel made a motion to reconsider right before, on the eve of trial, literally, like I think on the eve of trial, right?
Yes.
And arguing that the CI testimony to the trial judge, right? It was a different motion. It was a motion for disclosure of the CI.
Correct.
Right. So how do we import, evidence taken from a separate evidentiary hearing?
Well, I think it's the same as any other kind of motion. It's the law of the case until there's some reason to reconsider it, and it's not too late to reconsider it even during trial. And that's what Judge Raschuti did. We're just...
He was not the motion judge, right? So shouldn't the motion for new trial have been heard by the motion judge, not the...
Well, it wasn't a motion for new...
It was a motion to reconsider.
It was a motion to reconsider. Well,
a decision that a different judge made.
That's true, but I mean, that happens from time to time. When there's a motion in limine and the facts come to light that merit change, I mean, it would have been... They're in the middle of a trial, so I think it would have been kind of tough. I don't know if Judge Donatel was sitting in where she was at that time, but from our position, it's just the same as any motion where a good cause arises for a judge to reconsider it. And I would submit this is good cause because Judge Donatel only heard secondhand what this confidential informant was saying. And as she heard it, he said, Tony Evans has a gun, which is a very different thing from what Judge Raschuti wrote in his written finding, which is Tony Evans was looking for a gun and he was going to go talk to this person, Abigail Gatu.
But that's not what she found. That was not her findings of fact on a motion to suppress that occurred 5 years earlier. She found exactly the opposite of that.
I know, but that's what I'm saying is interesting, is because Judge Raschuti did find it. I mean, it's a written finding.
So what?
Because he talked directly to the confidential informant himself.
5 years later.
5 years later.
Yeah.
Yeah. He knows something that she did not know.
So you're saying his findings somehow trump her findings? Is that what I hear you say?
Yes, because I'm saying his finding directly, to the extent there's a contradiction here, it's the Commonwealth's burden. It was a warrantless search. They have the burden. And I would submit, yes, he had it directly from the horse's mouth. He had the confidential informant there. He found him credible. And he said that as of the time of trial, 2023, he still did not know whether Evans got a hold of the gun, which makes no sense at all. If what the officer Burroughs said was he has the gun, I know he has the gun. He called him back to insist you guys missed it, even though they did a thorough search of everyone in the car. That makes no sense at all if the guy is saying creditably to Judge Raschuti, this is what I heard, that, it sounds more like a rumor to me. He's looking for a gun. It's a totally different finding. So it seems to me, I guess, that one of their findings has to go, and I would submit that the more specific one by Judge Raschuti, who talked to the confidential informant.
5 years after the fact.
It's 5 years
after the fact, after the double homicide.
5 years after the fact. Yeah, it was 5 years after, well, let's see, 20, yeah. So certainly the officer spoke closer in time to the shooting. I'm not going to deny.
The confidential informant said that he had no memory of calling back and saying, you missed the gun? He didn't say he didn't say it, right?
He said he had no memory, yes. But it doesn't really make a lot of sense. If his testimony, Judge Raschuti, was, I heard he was looking for a gun, I don't know if he got the gun or not. So it doesn't really make a lot of sense that if that's his testimony, he would be calling back to insist he has the gun. That makes it sound like he saw him with the gun. When you read Judge Donatel's decision, you get the impression he saw it firsthand, or he had some kind of percipient knowledge that he had a gun, and then you get the true story from.
If we're not persuaded by the contradiction, or we say we're not going to, credit the subsequent testimony by the CI to Judge Raschuti, but we're looking just solely at the findings and the evidence that was presented at the motion to suppress, heard by Judge Donatello. Do you want to address whether that evidence?
Sure. I mean, the other issue here is, I guess, that it's a two-part search. So there's a search and seizure the first night at the restaurant, and then the next day they see the car. Our position is it was 12 hours later. It's a gun. So it's a gun, and the people knew that they were being surveilled by the police because they've been searched. So it would have been stale anyway the next day. And I know the Commonwealth makes an argument that, you know, this is a high crime area. There had been a shooting.
Double shooting, right?
A double shooting, a murder, double murder.
Right.
People were at large. That's certainly all true, and it's important to consider. But the fact
is that not sufficient? And your argument is that is not sufficient.
No, I mean in Dorchester, I imagine at any given time there's a lot of illegal guns on the street. So unless there was some particular evidence tying, you know, Tony Evans or Steve Stephen to these shootings, but that's not in the record. That's not in the trial record that I see. So it's just there had been a bad tip about a gun the night before, and then there's a shooting, and that's the basis for the stop. I'd submit that's not enough, especially 12 hours later when I think the Karen K case says 3 hours is stale.
Was it a bad tip? Because everything, well, they didn't search the female passenger, right? Everything else checked out. The license plate, the make of the car, it was behind flames, the people who were identified in the car were with the CI.
Yeah.
And the CI had previously had, you know, been credited, had a history, right? And so isn't it almost as though he's essentially saying, well, you missed, it's there, you just missed it, right?
Well, if that were the case, and I believe that the female, they didn't pat her down, but they checked her. She was wearing tight clothing, I think, and they checked her pouch or her sweat. But even if we credit Judge Donatello's finding that he said you missed it, and we ignore what was said to Judge Raschuti, it's still 12 hours later, and really all you have to go on is there was a shooting. It has to do with firearms in Dorchester, and I submit that's just too.
It's more than that, isn't it? It has to do with firearms in Dorchester. It has to do with gang or known gang affiliations. It has to do with a specific department or arm of the Boston police. I mean, the victims were known to be gang folks, right? The two victims who got killed that night were known to be gang folks by the Youth and Violence Strike Force or whatever.
I don't know that Montgomery, the female, was, but I guess, yes, that there was talk about various people are either suspected to be in gangs or affiliated.
The names, the names that were provided to the officers,
Right.
and this is, again, the gang unit, they were, or Youth and Violence Strike Force, whatever.
No, I agree that.
They were familiar with Evans and Jones and knew that they were involved in firearm-related incidences, right?
I don't know that that's the case. They knew about Evans, certainly. They knew about Stephen, but I guess what's missing here is any kind of connection between. There had been 3 shootings the night before. There were the 2 that are.
An unrelated other person.
Right, and then another one, and there's no evidence in here that these gangs were hostile to them or that anyone knew each other. It seems to me it really, aside from just using the word gang, you have really here just a case about an apparently bad firearm tip followed by a shooting, and it's 12 hours later, and we'd submit it was stale. But
So is it your position that when the police saw the red Chevy the following morning, I think it was a Chevy, I forget, but the red car the following morning,
yes,
they should have just let it pass and without inquiry?
I guess they could have surveilled it. I mean, there's steps the police can do short of, and this goes for the night before. If they really heard he was looking for a gun, that certainly justifies surveillance or ask.
That's not the information that they had, it seems.
No, I understand, but I guess
the information was he had a gun.
There's steps they can take less than doing nothing and making a full search and seizure, I guess, is my position.
Want to talk about the jury instruction, or have we already touched on that with respect to?
I think we talked about the jury instruction,
respect to
yeah.
the
So, I
timing.
mean, that's sort of part and parcel with the, whether the indictment that tracks what he was convicted for. I'm out of time. I made a sufficiency argument. I'll just say it seems to me it was a close case because of the limits on the DNA evidence, which was potentially touch DNA.
All of that information came before the jury? The fact that it couldn't really tell that it was a DNA mixture, it wasn't
They did, yeah.
as conclusive as...
They did, yes. I mean, so the jury knew that, but that's often the case with sufficiency arguments, as you're arguing the jury got it wrong. It seems to me it was a close case, and in our estimate, it was just on the insufficient side. But you know, if it had been a fingerprint, certainly Mr. Jones would have some explaining to do. But because it was a minuscule amount of DNA and it was a mix with several other people, he really just had that he had been with the other two people in the car 6 hours earlier at Dunkin' Donuts. We'd submit that's not enough, but.
Attorney DeMaio, getting back to the suppression issue.
Okay.
Did you properly raise on appeal the issue of whether or not Judge Raschuti, the information that he received from the confidential informant, whether we can consider that as part of Judge Donatelli's ruling? What I mean, stated otherwise, defendant, your client filed a motion to reverse the motion to suppress.
Yes.
That's what Judge Raschuti denied.
Right.
There are no written findings on that, correct? There's a margin order?
He ruled orally, yes, for that.
So is that before us, or are we bound by just what Judge Donatelli heard and found?
I guess our view is under Rule of Appellate Procedure 3, when you file a general notice of appeal, it calls into question all the pretrial rulings and trial rulings, and this is one of them. I guess this sort of touches on the issue earlier that Judge Donatel was the one who made the initial call on this, but it was certainly brought before Judge Raschuti's attention, and he made an oral ruling specifically saying, I hear what you're saying, I understand you, but I'm not going to reverse her because
We're not the fact finders, so would you suggest we take the facts that Judge Raschuti found and the facts that Judge Donatelli found and then analyze those facts, whether there's sufficient basis, or are we, I'll ask your brother in a moment, that's what you would suggest, correct?
I do. I mean, I guess and that's why I said this is an interesting and difficult case, because you have the two findings that, at least in my opinion, are in tension with each other. And to the extent it's hard to know what to do, it's the government's burden. It's a warrantless search, and I get that the Judge Raschuti was talking to the informant 5 years later, but that gets into weighing the evidence. So I would submit. You know, the Judge Raschuti, the court has to consider seriously what Judge Raschuti said, since he actually talked to the informant and Judge Donatel didn't.
So Judge Raschuti denied the motion to reconsider?
He did.
And did you appeal that?
Again, I mean, I put it in the brief.
Specifically, was there an appeal to the denial of the motion to reconsider?
That is not mentioned specifically in the notice of appeal. It's just a general Rule 3 notice of appeal. Yeah.
Anything else?
Thank you.
Thank you, Attorney DeMaio. Now we'll hear from the Commonwealth. Attorney McLean.
Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth. I think we can move through the Guardado issue very easily. I do agree with opposing counsel that Crowder controls.
We need to reset the clock.
The clock hasn't
Hang on.
started.
I'm sorry. Good morning. May it please the Court. Ian McLean on behalf of the Commonwealth. I think we can dispense with the Guardado-based issue easily. I do agree with opposing counsel. Crowder controls. This case did occur after Bruin, but before Guardado, so
We get to retrial.
Yes, sir. It is subject to retrial.
All right. So how about you pick up where Attorney DeMaio left off, which is, well, not quite where he left off, but so there's a principle that says, you know, you can't really have it both ways. You can't invite the error and then complain of it. And so what do you say to the representations that the government made with respect to the firearm at issue, which seems to be pointing directly to the gun in the hand of a killer on the early morning hours and not a gun somewhere found later on the street?
Yes, sir. So the instructions question. The argument that was made by the ADA during the motion to suppress was an argument about standing. She was fighting about the separate standing requirement that existed back in 2018 and was done away with by DeJesus in 2022. And what she said there in that standing argument was mistaken. And what she said in that argument on standing in the motion to suppress does not trump the charging instrument, the indictment here, that specified the day and only the day. To the extent there was any confusion that was created by the argument that she made about standing during the motion to suppress, the defendant availed himself of the appropriate mechanism. He filed a motion for a bill of particulars to ensure that he understood what he was defending against. The Commonwealth filed a response to that and clarified, to the extent any clarification was necessary, which I don't believe there was, but indicated that the charge was as stated in the indictment. It was covering the entirety of the day. So he had to defend himself against both the time of the murder around 2:43 a.m., presumably he would have had the gun before the murder occurred, and then after the murder throughout the morning hours until it was ultimately abandoned on the street at 10:30 in the morning. And the charging instrument indicated that, the bill of particulars indicated that. So the defendant was on notice of what it was he needed to defend himself against, and there was no objection at the time in response to that bill of particulars. So the mistaken argument that the ADA may or may not have made when she was trying to argue about the separate standing requirement and then arguing against automatic standing and those things on the motion to suppress don't trump the charging instrument is basically the Commonwealth's response on the jury instruction question.
What do you say to the stop of the car in the morning after the homicides?
Yes, sir. So opposing counsel did mention probable cause several times, and we think it was just a stop. So the question is reasonable suspicion or not. So specific and articulable facts of criminality, basically, is what we need to stop that Chevy Cruze in the morning. And I'd say we had three things. We had the combination of the first tip, the second tip, and then we have the officer's knowledge of the suspects, and then we have this, basically the seriousness of the offenses that we're talking about and the massive public safety danger that we were dealing with at the time. So I can address each of those sort of three components, if you would.
So we get the first tip.
Okay.
They search the car, they search the two occupants, the named people that they expect to find in the cars there behind the restaurant. And if you credit the second tip, which is you missed the gun, that also seems to be supported by the police actions themselves. You know, they went and they saw the car, they saw the people. They know that they didn't recover a gun after having searched the three people, although they didn't really frisk the woman.
Correct, sir.
But fast forward now to the following morning. How do you stop the red car again?
Well, so, sir, I'd start with, we're on the same page about tip one and tip two, it sounds like. Judge Donatelli found that because the confidential informant that provided the tip wasn't there, we had to corroborate the tip to establish the deficiency, basically, in the basis of knowledge and the veracity. And Judge Donatelli found that we did accomplish that through all of the details of the tip that were confirmed. The specific occupants of the vehicle, where the vehicle was, the plate of the vehicle. And then, yes, sir, they did a frisk, both of the two male occupants, Stephen and Tony Evans, found no gun, and they frisked the interior of the vehicle. Not a full search, a frisk of the vehicle. They did not frisk the woman that was there, Abigail Gatu, because they had no female officer available.
And because she didn't appear to be able to hide the gun based on the clothing that she had on.
So, sir, my recollection is she was wearing tight, like spandex-style pants or shorts, but a baggy sweatshirt over it. So it's entirely possible that the gun was tucked into her waist and the baggy sweatshirt was covering it. Entirely possible.
You don't think the officers were looking for the gun?
I think they were looking for the gun, Your Honor. I think at the time in 2014, they were concerned about male officers conducting a frisk of the body of a female person they had just stopped. So after they frisked the two gentlemen and then they frisked the interior of the car, they decided not to detain the individuals longer, waiting for a female officer that they had no idea when they'd be able to locate a female officer to frisk her. So they did what they did. Those were their police practices. Now, that there was a subsequent tip that you missed the gun. That comes in, and we've got to revert that back to Judge Donatelli, basically saying you had corroborated enough of this tip that you could rely on it, which I think then carries over to the second tip. So now at about, I'm not sure exactly what the time was, 11:30 or so, they have a second tip that that person, it was Stephen, not Tony Evans, has a gun. Then over the course of that night, what those officers learned at roll call the next morning, there were two separate shooting incidents. One fatality, Julian Printemps was killed, and then at 2:43 in the morning, this atrocious double murder on a residential street in Boston where there were, I believe it was 26 shots fired, 26 shell casings recovered. One of the victims shot 15 times. The female shot twice in the back as she was fleeing. Now, what else did the officers know? They knew Tony Evans and Steve Stevens were both in gangs. They knew Steve Stevens had a prior firearm conviction. They knew Tony Evans had been stopped multiple times around shootings, during shooting investigations, knew they were both gang members, knew that Steve Stevens in Thetford, his gang was in an active, violent feud with another gang. And they know there were 2 different shooting incidents with increasing levels of violence. And the second one, 2 murder victims on a residential street with 26 shots fired. And they know that they still have a tip that I say is valid about Steve Stevens having a gun.
But nothing connected Mr. Jones or his co-defendants between the deceased? Nothing specific, correct?
No, but the officers did also know that 2 of the 3 fatality victims from the shootings the night before were gang members.
Which 2?
Julian Printemps, not related to this case, and the male from this case, Clarence McGregor. So they know that we have 2 separate shooting incidents, 2 separate gang members. We're not in the same gang. And they know they have 2 gang members, one of which they have a tip has a gun, and they know both of those guys have a history of firearms and being around shooting
There's
scenes.
no evidence that the defendant or his co-defendants, that the groups that they were associated with were any feuds with the deceased, correct?
At that time, no. At that time, no.
There's no evidence tying the vehicle, the red cruiser, the red vehicle to the murder scene, correct?
Yes, but the homicide detectives were aware of a red or maroon colored car that was at the scene. And we're talking about a red Chevy Cruze, but it's not clear that that level of detailed information was communicated to the Youth Violence Strike Force
At
gentlemen.
which scene?
At the murder scene,
Which murder?
the second murder, the murder, this case, the double
The
murder.
2?
Correct,
The
sir.
double murder.
But at the time of the stop, these officers who made that stop that morning didn't have that information about the color of the car, correct?
I have nothing in the record that indicates they do. So what I have is I say the validity of the 2 tips. So we have an existing firearm, and then we have all of their knowledge about the people that this tip is about. And then we have, I don't know if you remember that night in Boston, it was a terrible night in Boston, and the morning was a real public safety threat and concern that we were on the verge of a gang war that was about to break out in the city. So this is not just in line with the cases where the police are investigating a shooting or a potential fatal shooting. This is 1 murder and then a double murder with 26 shots fired. This is a drastic increase in the level of violence that they were dealing with. So those cases that talk about the nature of the crime that's being investigated is a plus factor sort of in the reasonableness of their suspicion to conduct a stop in the aftermath. Here that's got to be increased or amplified because of the level of public safety concern that we had in the city that morning on the basis of the events that had happened the night before between gang members. If they're willing to squeeze off 26 rounds on a residential street, who knows what's coming next? And that's what's going through those youth violence officers' minds that morning when they see a vehicle that they have a tip for that has a gun connected to it. And again, please.
Was the gun connected? Sometimes there'll be a tip, a gun is connected to a vehicle, but the tip was, in the light most favorable to the Commonwealth, the gun was related to an individual who was in the vehicle, correct?
Correct, sir. Correct, sir. Absolutely. And
The officers saw the car that morning. They didn't see any of the occupants, right? They didn't identify who was in the car before they stopped it.
no, they did not. As they stopped the vehicle, it initially stopped. They approached the vehicle. As they got up near the vehicle and could then see there were multiple occupants, but they couldn't tell who
They
were.
could have done further surveillance to see who was inside the vehicle. Would you agree?
They could have tried, but you have to keep in mind that this is in light of the events that had taken place the night before, where we have at that moment.
What if they did see, hypothetical, they saw the car and they saw the driver was the owner. I don't remember her name, but she wasn't, let's say she wasn't affiliated with any gang. She was the owner of the vehicle. She was by herself. Could they have stopped her on reasonable suspicion that the vehicle had a firearm?
If they had knowledge that such they could see there was no one else in the vehicle, then I'd say maybe not. At least we'd be at a much closer case then, because the tip they had was Steve Steven has a gun and he's in this car. So the tip is tethered
It was the night before.
Yes, the tip was tethered to Steve Steven, not to there is a gun stashed in the car.
And it wasn't Steve Stevens who was connected with the owner, it was Mr. Jones, correct?
Correct. But when they went to go investigate the tip, The three people that the tipster said would be in the vehicle were in the vehicle: Steve Stephen, Tony Evans, and the unidentified woman, Abigail Gatu. But the three people the tipster said would be there were there. So the next morning, there are three people in the car again. Just trade out Steve Stephen and place Lorenzo Jones in the car, ultimately, is what.
But they didn't see the three people until they initiated the stop.
Correct, Your Honor. But I would say that they would have enough on the basis of the events of the night before and the tip about somebody in that car having a gun. I would say they would have enough to do an investigatory stop. And again, it's just reasonable suspicion, specific and articulable facts. Those are specific and articulable facts. They're not stopping this car on a hunch thinking, oh, red Chevy Cruzes, people that drive Chevy Cruzes carry guns. They'd be stopping that car because they had a tip that someone in that car had a gun, and that person.
A tip to having somebody has a gun is not a tip that this person has a gun and is about to commit a homicide.
Correct, but they did know that he had a prior firearm conviction, so they know that he cannot have a gun, so they know that's a crime.
Yeah.
Automatically already know it's a crime, and then place it in the context of the events the night before.
Right, but there's nothing linking that gun to the homicides yet.
Correct, Your Honor, but in all of those cases where they talk about the crime you're investigating is can be a plus factor if it's a public safety risk, a serious
Right, but
public
they weren't
safety risk.
investigating a homicide yet. They were investigating a gun. That was the crime that they were investigating when they went to Flames the night before. There had not been any homicide, right?
Yes, sir. I'm not positive about the timeline. The Julian Printemps murder might have preceded that stop at Flames. I think it did, actually, but I'm not sure the record is clear on that.
I didn't see that in the record.
But the point is, in the morning, they know a person they know that has a history with firearms, is in a gang that is in an active violent feud, has a gun, and they know what happened the night before. So if they need reasonable suspicion of criminality, it's going to be for possession of a gun because they know he cannot lawfully possess a gun. But they are certainly investigating that gun in the context of the events of the night before, which again were horrendous events and looked like the beginning of a massive gang war in the city.
How do you respond to opposing counsel's argument about the inconsistent statement that the confidential informant gave in the subsequent hearing in front of Judge Raschuti?
Of course. So it was a reconsideration motion on the motion to suppress, and Judge Raschuti denied it without an evidentiary hearing. So we have the facts that we have that Judge Donatelli found in her initial ruling 5 years before that. The interview that Judge Raschuti did with the confidential informant had to do with a different motion the defendant had
So
filed.
the motion to disclose the identity of the CI?
Yes, it was a
Right.
discovery motion. And for safety purposes, because Judge Donatelli had previously found this CI is in serious danger, Judge Raschuti held an ex parte hearing and interviewed the person, denied the motion for discovery. So there's separate questions. So we're already talking about bleeding findings from one issue to another issue. The reconsideration motion was denied, and the motion to suppress was denied without an evidentiary hearing. So there are no actual facts. But even if you wanted to sort of import that interview as factual findings on the reconsideration, I'd point out, Your Honor, as you noted, the confidential informant did not say, I did not call my handler at BPD again.
He said they couldn't remember.
I don't remember. And it was more than 5 years, sir. It was close to 10 years. The murder occurred in January of 2014, and that interview with the CI was in February of 2023.
But he or she, they had a specific memory that they didn't say Steven Stevens had a gun on him. They said they were looking for a gun, which is dramatically different, you could say, from what the detective testified to, that they had a gun.
It's certainly different, sir. Yes, I would certainly agree with you that it's different. But I would also, I'd go back to the same thing that the tip, Judge Donatelli found the tip was corroborated by all of the details of it that the officers found that night. And I would point to the fact that the motion to suppress hearing when the officer testified about it was in 2018, so we're 4 years after that night in question. And when the CI is interviewed, we're now close to 10 years after the night in question. People's memories fade over time as to what exactly they said or saw. But even if the CI said exactly what the CI remembered having said, that Steve Stephen was looking for a gun, not Steve Stephen has a gun, Judge Donatelli found there was enough detail of the tip corroborated at the time that the tip could be relied upon. And the tip, as Officer Burroughs understood it, was Steve Stephen has a gun.
Well, certainly he's looking for a gun changes the whole analysis, right? I mean, there's nothing criminal about looking for a gun.
Yes, sir. I suppose it maybe be an attempt offense, it's maybe, but yes, sir, that would change the analysis. But I stress that the interview with the CI was close to 10 years after this event happened, and the officer was credited at the motion to suppress hearing.
If that were the finding, though, looking for a gun and not had a gun, do you believe the stop would be supported?
Yes, I do, because it's just an investigatory stop to confirm or dispel a reasonable suspicion of criminality. And the criminality doesn't have to be happening at that time, it can be about to happen. I mean, the original Terry case, they were casing a joint when they stopped him. So it can be criminality is about to occur, criminality is ongoing, or criminality is going to occur. So this would be criminality is about to occur. So I still think there would be a legitimate basis for a stop to confirm or dispel whether he was, I mean, it wouldn't be much of an investigatory stop. Are you looking for a gun? No, I'm not. Okay, we're done. But you could still stop a person if they're about to commit a crime.
And what's your best case for that stop in the morning, the following morning? What's your best case?
My best case for the legitimacy of the stop in the morning, it's going to be a combination because it's based on a series of factors. But Sweeting-Bailey would be the ability to rely on your knowledge about the defendants and their criminal record and their criminal background, as well as Johnson. And then for the overall seriousness of the thing that they were investigating, the public safety risk, I'd probably point to Van Rader.
I mean, you agree with me that, and maybe you don't, I don't know, a shooting in a gang-related shooting at the early hours of the morning is not a shooting at noon at Faneuil Hall.
Certainly true, certainly true. But here it's not one shooting incident, it's two separate shooting incidents with an increasing level of violence. And the second one, 2 victims and 26 shots fired in the city on a residential street.
Anything else? I see you at the chime.
Thank you, sir.
Thank you both. Well, argued very well on both sides. Thank you kindly. Matter is submitted. Next matter on our docket, 24P 1107. I'm not going to announce the names because I don't want to butcher them, so I'm going to ask somebody to pronounce the names for me.
Yes. May it please the court, Your Honor, Joseph Lipchitz on behalf of appellant SZAWLOWSKI Realty, Inc., known and referred to as SRI. At the heart of this appeal is the land court's erroneous decision ruling that the son of a corporate officer of SRI had acquired title to corporate property that he was living in with permission through adverse possession using his father, Stanley Sr.'s purported adversity and possession, notwithstanding 1, his father's fiduciary obligations to SRI, and notwithstanding 2, his repeated written acknowledgments that fee simple title rested with SRI, as he acknowledged repeatedly in mortgages that he signed in 2000 and 2006. So the land court's decision disregarded controlling Massachusetts law in 3 fundamental ways that not only mandate that the decision be vacated, but that judgment affirmatively be entered in SRI's favor. They are as follows. 1, the court's legal ruling as a matter of purported first impression that a corporate fiduciary can adverse possess against his principal was clearly erroneous. 2.
Counsel, can we?
Go ahead.
Go ahead. So on that fiduciary question, right, this case was not tried. No one mentioned fiduciary. No one mentioned this argument at the land court trial, right? None of the parties, not the judge. It wasn't tried that way, right?
Correct.
That defense wasn't raised at all. And it was the judge who made that, the findings of fact and conclusions of law mentioning this.
Correct. He made that ruling on his own sua sponte after trial. And as we submit, that legal conclusion that he made is still entitled to be reviewed on appeal.
Right. And so he cites 2 out-of-state cases, the Illinois Paravoliotis and the Lee case, the New Jersey case, in support of his conclusion of law. And how do you respond to those? And I know that those courts never actually reached that issue of whether a fiduciary, one can adversely possess, right? I think those courts made the finding that appropriate notice wasn't given. So is that how you're distinguishing? And I know you cite at least 2 out-of-state cases, the Utah and Arizona cases, which do explicitly state, right, that
Right.
Let me,
Well, I think I address it in several points. Number one, they're not controlling authority.
Right.
We have Massachusetts and Supreme Court authority right on point. And I should pause before we get to that authority, that at the threshold, SRI is a closely held Massachusetts corporation, which means that the shareholders and officers owe not only fiduciary duties, but the utmost good faith and loyalty, as the SJC has said. And so for over 150 years, fiduciary duty law has made it clear that you can't have a fiduciary, corporate or otherwise, trying to possess property, interests, assets of a corporation. So as Jackson versus Ludling, the Supreme Court case we cite in corporate fiduciaries, quote, they have no right to enter into or participate in any combination, the object of which is to divest the corporation of its property and obtain it for themselves. You have the Supreme Court decision in Lewis saying, quote, there can be no adverse possession by, in that case, a trustee during the continuance of the trustee relationship. You have the SJC in Black versus Parker Manufacturing that we cite, that says, given the paramount duty of loyalty in the corporation, a director cannot be allowed to profit personally by acquiring property.
Let me ask you this question. Why wasn't that the first argument on appeal? Why is that argument not raised in your brief?
I'm sorry, I'm confused.
And why SRI didn't rely on that argument, right?
at trial, you did not.
Oh,
right?
on trial, yes.
Yeah.
Because it definitely was raised on appeal.
It was raised on appeal as a result of the judge's ruling.
Correct.
Right, so I'm asking a different question.
My answer to your question is I can't provide the answer because I wasn't trial counsel, but I will say that regardless of whether it was briefed or not briefed, it is amenable to review on appeal for several distinct reasons. Number one, it was a legal conclusion that the court affirmatively raised on its own, sua sponte, and based its opinion on, and therefore, under the case law, including the First Circuit's decision that we cite in Fidelity Co-op, that's ripe for appeal. But even separate and apart from that, Massachusetts law, and we've cited the cases to you, SJC and appeals court, that say that trial judges sitting in jury-waived trials.
No, I understand that principle of law, that they're going to instruct themselves on the appropriate law that applies. Go ahead.
Correct. And further, as the SJC made it clear in Demoulas and its progeny, that the reviewing court has an independent obligation to ensure, in the SJC's words, ensure the judge's ultimate findings and conclusions are consistent with the relevant law.
But that happens for bench trial or jury trial, right?
Correct, but here you have the judge clearly making a clear error of law as to the fiduciary duty issue. So I hope I've answered your question as to those cases.
Can you address the adverse possession? So let's just put aside, the issue of fiduciary duty. What about the judge's analysis? You're arguing that he was incorrect in his evaluation of whether or not the adverse possession was shown.
Correct. So it's important, and this gets to the second legal error, also the third legal error. This was a possession that was started with permissive use.
Right.
Right?
So there's a heightened standard, right?
And so it's a heightened standard.
And the judge found that the adverse possession period began in 1999 at that heated family meeting, right, in which I'm going to call him Senior. Stan Senior said, this is my house, and banged his, and so the judge made that finding a fact, right?
Correct. And so let's start with the legal standard. So given that it started with permissive, as this court has said in Begg, that you need to carry, the adverse possessor has a heavy burden to show with clear evidence that the use had switched from being permissive to adverse, sufficient to put someone, the true owner, on notice of a claim of adverse title.
Was that sufficient, that meeting?
And I say no for several reasons, Your Honor. Number one, he's a fiduciary. And as this court held in Geller versus Lyons, the duty of disclosure by a fiduciary isn't satisfied by sotto voce indications. It's got to be a full-throated disclosure. And here, I think the language of Geller is important.
Isn't he telling them in no uncertain terms that this is my house? No, because they're saying, hey, why don't you move? And he says, no, this is my house. Is that not clear?
It is not clear because, again, as this court made clear in Geller versus Lyons, no half-hearted disclosure or partially discovery would satisfy the corporate fiduciary's obligation to make full disclosure. Rather, the corporation must be appraised of all material facts as well as their legal effect. So that's point number one. So just saying it's, quote, his house.
But he does a little more than that, right? He says, it's my house for all of the work and labor that I've put in have not been compensated for.
Right, that's slightly different than saying I'm adversely possessing the house. That reflects an interest that somehow...
There's no declaration that says I'm adversely possessing the house. The declaration is, this is my house, contrary to yours, SRI, and this is why it's my house.
And it was in response to them suggesting that he move out. He says no. He refuses, and in fact, he doesn't. He and his family continue to stay and live there for...
He doesn't, and to your point, is that enough? And I say no, because literally within 11 months or less, after that purported conversation that we obviously contest, but...
Well, the judge found it, right? The judge
found it. In 2000, so less than 11 months later, Stanley is signing mortgages saying, no, SRI, you have fee simple absolute, and not only that, but I represent on behalf of the corporation, we are not going to allow anyone to acquire any legal or equitable interest in the property by anyone. And he does that in 2000, and he does it in 2006. So given the higher burden imposed on the permissive use that it started with, a single conversation in 1999 that is then reversed in 2000 and 2006 is insufficient as a matter of law to convert this into an adverse possession claim.
But doesn't Stan Jr., and I think opposing counsel makes this argument, and the judge found, I think, Stanley Jr. alone, he's not tacking on to his father's interest, right, in terms of that he himself, just his time alone, meets the 20-year requirement as uninterrupted. So how do you address that?
Yeah, so here's the fundamental problem with that. He presented, and down below, Stanley Jr. presented the adverse possession claim as both on behalf, he relied on Stanley Sr., the father, and his own time. Now on appeal, when all these legal errors have been made clear, he says, oh, no, I satisfied adverse possession independently. Well, he needs to establish exclusivity and adversity for 20 years.
So what does he point to?
Exactly. So again, if you're looking at Stanley Jr. as an independent standalone entity, again, he moved into the house with permission. So
what does he point to? When does he say the clock began?
The only evidence in the record is a conversation in 2008 where they ask him to think about leaving, and the testimony is either he would think about it or that he was disinclined to do it. So
hold on. So is that when he says the clock began for him? Is that when he says that's the date of his beginning the adverse open use?
It is unclear based on the record as to when, and on the appellate briefs, when Stanley Jr. claims the adversity, because he's trying to...
He's the only one named in this lawsuit.
Right, but what Stanley Jr., the point I'm trying to make, Your Honor, is Stanley Jr. tries to reach back while saying he's independent and relies on his father's conversation
But it
in
seems like he's
1999.
distancing himself from that now, right?
Correct.
So now I'm trying to figure out if he is indeed distancing himself from that now. So when does he assert the clock began? It can't be 2008 because that's not 20 years now.
And that is exactly our point. But what I'm trying to do in answering your question is the only evidence in the record of Stanley that could even arguably be pitched as a notice that would be sufficient to change it would be this conversation in 2008, which, as you point out, is insufficient as a matter of law because of the time, among other things. So getting back to the fiduciary duty legal error, I just want to briefly touch on the fact that, as our briefs make clear, there is this well-established body of fiduciary duty law in Massachusetts. And the court, rather than focusing on the fiduciary duty law that we have, focused on Totman for the claim that somehow that a corporate fiduciary could adverse possess against his principal. Totman...
That dealt with siblings, right? A family. It wasn't the same type of closed corporation.
Correct. It didn't even have anything to do with fiduciary obligations. And again, moreover, that dealt with, the Supreme Court held that the trial judge erred in applying a presumption of permissiveness in the context of adverse possession among family members.
So this is kind of a belt and suspenders type of argument. If we don't agree that they didn't have the 20 years of adverse possession, then we can rely on the fiduciary argument?
Correct, although I would, and you see, we put in our brief, the fiduciary aspect of it is so clearly erroneous. But even putting that aside, Your Honor, the mortgages and the legal impact of the mortgages also establishes he doesn't have 20 years. And even if you look at Stanley individually as an entity, standalone, he doesn't have the 20 years.
The mortgages
deal with the dad, not with Junior.
Correct.
And that wasn't raised at the land court either, right?
Beg your pardon?
That issue was not raised.
Oh,
at
it
the land.
absolutely was.
Well, in terms of it being, that was I think introduced at the land court as showing a sort of permissive use, right?
Well, it would show that there was no adversity because it was permissive use, and it was specifically raised in the pretrial brief. So it was raised, briefed, and by the way, as we point out in our if you'll permit me to answer this question.
Yes.
The trial judge knew what the law was. He applied the law appropriately when it came to Stanley deeding the property to SRI in the first place in 1990, said, look at his acknowledgement by deeding the land to SRI, that interrupted any adverse possession, so he applies the law correctly there, yet when Stanley turns around and signs mortgages for the very same property in 2000 and 2006, he doesn't apply the law. Barring any questions, I see that my time is up.
Thank you kindly.
Thank you.
Good morning, Your Honors. Excuse me. And forgive me, I'm a little hobbled if I lean. Your Honors, the land court applied the exact legal standard.
So let me just so I can understand the framing here. Is it your position that, I'm going to call him Stanley Jr., has 20 years of adverse possession standing alone without tacking on to his dad?
Absolutely. And that is what the land court specifically found.
So just so we're clear. And so what date do you point to and what action do you point to where he provided the requisite notice? Junior.
It's in 1999, and there was some confusion at trial whether it was 1998 or 1999, and I think the judge appropriately found it to be
1999. What did Junior do?
Junior was at the meeting that the judge, the trial court judge, refers to which was testified at length about at trial. It was,
But hold on.
yep.
But did Junior talk at that meeting?
Junior did not talk. He was there.
So he was at the meeting when the father was jumping up and down and banging the table, right? This is the meeting we're talking about?
Yep.
All right. But that was what the father was representing, right? Junior was just there in the room. So I'm asking, what did Junior do? What specifically did Junior do, say, to put SRI on notice that Junior was now living there adverse?
Your Honor, he did exactly what the law requires, which is he made as crystally clear as
I'm asking what that was. Tell me what that was.
He engaged in non-permissive use of that property before, but then more particularly going after. He was with his father. He was adopting his father's stance.
How do we know that?
Because he was an adult. I think he's,
So just by virtue of him being in the room?
not by virtue, by what the law requires us to look at. The cases that SRI, a realty company, mind you, SRI cites the cases. It says exactly what you look at to determine adversity. And it's not just the relationship between the parties, but it is in part, it's absolutely positively, you look at the relationship between the parties.
What did Junior do to start the clock running? Can you tell me what he did to start the clock running?
He was occupying that house with his father.
To give notice.
Yes, with his father who gave notice. They don't have to both give notice. And the notice has to be that the use is adverse. That's the notice. It's just unmistakable to maybe the most important part, like our strongest witness at trial was the president of SRI. In 1999, the person that ran the businesses for the brothers.
Sister? Who?
The daughter.
Yes.
The aunt to Junior, the brother to Senior. I'm sorry, the niece to Senior. In 1999, the father, Frank, he ran the family businesses. He is the one that was pounding his fist on the table at that meeting where Stan Senior and Stan Junior are there. It's their home. It's the only.
And so at that meeting, as I understood the record, they suggested to him that he should move out.
They not suggested.
That's the language that they use.
No, they demanded. They
I
absolutely.
didn't see demand. I saw suggest. Point demand for me in the record.
And while I look, Your Honor, forgive me from.
Well, on page 5 of the findings, number 21, actually, finding 22, 1999, Frank and Chester suggested Stash move his family to the Main Street house and vacate Christian Lane.
Yes, and
So just to sort of, just to follow up a little bit on the questioning. So he refused, Senior refused.
He refused.
And at that point, that's where the judge says the adverse period began. But what more, as we discussed, earlier, there's a heightened standard, right? Because it began as permissive use. So to go from permissive use to adverse use, there needs to be clear, is it enough? Like, what else happened? What other indications did they give to SRI to say, well, because then they were allowed to continue to live there, right? Nobody.
say no, they were not allowed. SRI acquiesced. So what happened was there's an initial meeting where there's this pounding on the table, screaming and yelling.
Well, acquiesced, agreed, allowed. They continued to live there. They weren't forced to move out, right?
Your Honor, acquiesced is not enough to defeat adversity, which
Right. I saw the cases that were cited there.
So what they did is they continued to live there, which is what the case law says is the primary thing, after giving notice that they're not going to move out despite the demand or the very strong suggestion with pounding on the table and yelling. But then what Shelley SZAWLOWSKI testified to, on direct examination, not on cross from myself, Your Honors, she said that this conversation was happening every single day. And every single day, they were yelling and screaming. And I briefed this in our principal brief, Your Honors. That's Shelley SZAWLOWSKI saying that every day this conversation was coming up. It didn't happen at a single meeting. She said several times. She was asked by her own attorney repeatedly, yes. She was there for a number of them. Every day they were bringing up the same subject. Pretty much every day, what's going to happen here? Is Stan going to move? And then ultimately, they decide to give up. And again, this is on direct examination. Shelley is asked, forgive me, I'll refer to her by her first name because of all the SZAWLOWSKIs. Shelley's asked, did you decide to just let it be? And she said, yes.
It was 2008, correct?
No, this process of letting it be started, it was revisited later, it's true, but this was 1999. When it was coming up every single day, it was 1999. It was not 2008. In 2008, and the father did, in fact, begin moving someplace, living someplace else over a period of time. It was a transition that came up during trial. But the son remained. He's lived there since he was a kid. He's got a disability, a very severe disability.
The son's a sympathetic figure. I get it. I get it. And the wife, who also has a disability, right?
Yes, that's correct.
And they have limited means.
Absolutely.
And they, it seems in the record they didn't have any else place to go, right? And the family has been treating these properties and housing family members over time since the beginning of the potato farm.
Time, yeah.
I get it. He's a sympathetic figure. But
And
I don't know
SRIs
that automatically makes his adverse possession obvious or clear and obvious notice, which is the standard. So that's why I asked, what date are you telling me that began? And you're saying that argument at the family kitchen table.
It's when Shelley
When there was
SZAWLOWSKI.
only one SRI representative there at that time.
No, it's the whole family.
All four brothers
Shelley's
were
there
there?
even. Yeah, it's all four brothers. And then it's Stan Sr.'s kid, and sometimes kids plural, Joseph, my client's brother, Joseph SZAWLOWSKI, he was there for some of these meetings as well. It didn't happen once, and like the president, the current president of SRI
But
says,
the 1999 meeting, when that specific meeting, all four brothers were there? Is that what you're
all four
representing?
brothers were there, yes. In Your Honor, that specific meeting was the first meeting. That's when the adversity begins. But Shelley SZAWLOWSKI says it happened over and over again. Not just a conversation, but like the whole thing, the screaming, the pounding the fists. And I can cite the place.
But she doesn't go into that much detail, actually, right? In terms of, she just says, well, the conversations happen repeatedly. I think that was essentially what she said. She doesn't say that there's pounding and screaming and everything every day.
When she was
That's not the
asked
testimony.
about this particular pounding and
That one
screaming,
meeting.
she says that could have been any one of the meetings. It's just family. They're volatile. And I don't say that pejoratively. Like, I have a big, not to put evidence in here, but that's how they communicated about this particular issue. Some other issues as well came up during trial. It was volatile every time they discussed it. So she couldn't pinpoint which one it was when she was there or which one was the first one because it could have been any day. Those are the conversations they had about this house. It was,
She says here, Record Appendix 321 to 322, around 1999, these conversations occurred several times or repeatedly during the brothers' morning meetings where they would discuss the family business. It could have been any one of the days that I was there. I mean, every day they were bringing up the same subject.
Let me ask another.
yes.
You have a question? You?
No, go ahead.
Did anybody ever suggest or demand that Junior move out before he brought this summary process action?
In 1999?
I'm asking,
yes.
did anybody ever suggest to Junior? I haven't seen Junior speak up. You're telling me that the father said no, and the father represented, I'm entitled to this house because I've worked on so much and didn't get paid. Junior didn't make those representations, right?
No, but he was there with his father as
I understand he was there, but he's an adult. I understand he was there, but he's the only one named in this lawsuit.
Your Honor, So to rewind, I think there are a lot of mischaracterizations of the law generally by SRI on appeal, and I say that delicately, but nonetheless, emphatically. And the test, maybe if I could read the test that SRI cites to.
No, tell me the test that you think applies.
It's the classic test that's always applied.
Share with
And it
me.
goes right to it. It's just whether a use is non-permissive depends on many circumstances, including the character of the land, the identity of those who benefited from the use of the land, the manner in which the land was held and maintained, and the nature of the individual relationship between the parties claiming ownership. The fiduciary issue is not black letter law. Like, what my brother's representing is black letter law that was supposedly an error of law by the judge. There's a case that they rely on where there's a licensor and a licensee.
Was that the Concord? Was that Lewis, the Concord? Which,
No, Lawrence v. Concord, I believe, was a different one. I thought that was Begg, if I'm remembering correctly.
so which case are you talking about that you're saying they're wrongly characterized?
I was referring to Begg, which is the case that cites the quote I just read into the record was from Begg. And in that case, there's a licensor and a licensee. And the licensor and licensee could adversely possess. There's no case, there are cases that say a fiduciary is not supposed to hurt the interest of the principal.
Right, but nothing that says, we have is there a Massachusetts case law, and I think I know the answer to this, that addresses this specific issue of adverse possession being permissible by a fiduciary?
Not that I could find, Your Honor, and not in the record. It might be black letter law in another state. It's not black letter law in Massachusetts. In Massachusetts, the test is to weigh all this stuff. Now, when you have this close relationship, yes, there's a heightened standard. When it starts as permissive, there's a heightened standard. That's exactly what the land court did. It literally applied, and Justice Desmond, I think it was an oral argument in a previous case, you made a statement to the effect of you can't invite the error and then complain about it. Like, repeatedly, before, there's no affirmative defense on it, before, in the pretrial briefs, during closing, but during opening and closing, and after, in post-trial briefs, this fiduciary argument was never raised.
But, though, and I'm just going to interrupt you because I understand the waiver argument, and I think that would be pretty simple but the judge is the one he introduced this in his conclusions of law, right? In his findings, he's saying this is his first sentence, right? It's a case of first impression. So why shouldn't they be afforded the opportunity, even though no one raised it? They can't be expected to sort of stay silent and not respond to that, right? If that's what the judge's finding is.
My understanding is that, first of all, taking out a matter of first impression, I think he's right in the sense that you have adverse possession cases on all these different circumstances.
But not fiduciary.
We haven't had one with the fiduciary.
Right.
But it fits right in with all the case law that describes what you have to do to find adversity, including in other cases where there are special relationships. There's no case law that says you can't do it. And so he's highlighting, like, this is the first time we've talked about it with a fiduciary. But the judge did not entirely rest his decision on that.
That's right. There's actually underlying analysis about whether, in fact, adverse possession was shown, right? Like that's.
He focused.
We don't think we have to reach fiduciary necessarily.
Not to make their argument for them, but on the fiduciary question, they're saying it's dispositive, and there is case law that says if the judge makes an issue dispositive and decides something on that issue, you can look at that. But short of that, you've got to have enough support in the record that it was raised below. It just wasn't. Same thing with.
Right, but they can't be they can't be prohibited from actually addressing the judge's reasons for his decision.
I agree they can. But
Right.
it goes into the mix of how we define non-permissive use. The same thing with the mortgage issue never came up remotely but never came up remotely as a legal issue. The mortgage came up as it should have. It's a good fact for them. And then the judge has to take in all the facts and decide whether or not there was adversity. And that's exactly what he did. I mean, that's exactly what he did. And this judge, Judge Vey, to his great credit, The entire time there's testimony, being presented, he is like not missing a word. He feverishly is writing notes. He doesn't need to listen to the audio recording. He was dialed in. And when you look at the transcript, there's
At one point, he says, my pen ran out of ink, I think, right?
I forgot about that, but yeah.
You took a view?
One more
Where's
time?
the view?
You took a view?
He took a view, yeah. He drove out, he came out. I'm not sure that it's necessary to talk about the credibility of witnesses, but he heard a lot of evidence about the credibility of the witnesses.
Well, I just want to put the fiduciary piece aside just one more time, just so I'm clear. Did SRI ever ask Stan Jr. or demand Stan Jr. to move out of the house?
Yes, in 1999, it was
And the father was there?
when the father was there. They were there together.
And he sat silently at the table. There's nothing in the record that Stan Jr. spoke at that meeting,
No, and
right? Is that right?
that's correct.
You're saying it doesn't matter. He
There's
doesn't
a
need
case on
to
point with
because
that.
he's
What
part
case
of.
is that?
The case is, and forgive me, Your Honor, it's a case that, if I recall, I think they relied on Holmes v. Johnson for
What
this.
case are you saying is on point?
I was just about to say,
Holmes v. Johnson?
Holmes v. Johnson, it undercuts the argument they were making about the mortgages and the acknowledgement.
That's not what I'm asking you. I'm asking you,
Your Honor, I'm really trying.
go ahead.
So the standard that I've already articulated already existed. And in Holmes v. Johnson, this is like a turning point, not just Holmes v. Johnson, but the cases that led up to it, where the SJC had over time acknowledged that there aren't magic words somebody's going to say out loud. You focus on non-permissive use. And so in Holmes v. Johnson, that's where this court, the appeals court, was not making new law, but was clarifying the development in adverse possession cases. And this is back quite a ways at this point. I think it's 1949, Holmes v. Johnson was decided. At that point, there had been a little trend to focus on whether somebody said these words or said these words. And it's just everything becomes all about he said, she said. A lot of it ends up being hearsay, depending on who said it. And so the SJC had, before 1949, because in 1949, the appeals court says,
We're not going to go with the language. We're going to look more to the facts and the circumstances. I get it. That's not new law. So the facts and circumstances for Stan Jr. is when he sat at the table while his dad made those representations.
and then did all of the things that the law requires, both before, but then more importantly afterwards, because that's when the adversity begins.
What are those things?
Occupying the residence, and the judge made a very nuanced decision, carving up the land, which is difficult.
But that wasn't Stan Jr., right?
Yeah, absolutely. Stan Jr. talked about how he himself used, both during the view, but then at trial, he gave testimony.
I say Stan Jr., I mean the youngest son.
The youngest son,
All right, go ahead.
he and his family, but he, Stan Jr., used not all of the land that was at issue. And just for what it's worth, these mortgages involved 4 different properties. So we're just focused on one of the 4 properties in that mortgage. He lived in the house. He used all the house. There was barns. He used the barns. There's a field. He
Okay,
set
I
up a whole,
understand.
yeah.
Other than the 1999 discussion at the table when the father pounded on the table, is there any other point in the record where Stan Jr. refused to leave?
Like verbally?
Either verbally or after being asked and just didn't leave? Stan Jr.
He just.
Point to whatever occasion that is. Where
It's from 1999 on, Your Honor. He lived there knowing that he's been asked, directed vociferously to leave. And that is what the law looks like, not at the words. There are very limited circumstances where words can result in adverse possession, the adversity being defeated. Those circumstances did not exist here. And this is a realty court. Like, in all of those circumstances existed before we reached the 21st century. And all of this happened in the 21st century. It's like this realty corporation had access to lawyers and the law that would have told it how to take this house back, and they chose not to. Like, they just said, they decided to let it be, and I can give you the cases on acquiescence. I think you have them in the record. But acquiescing does not defeat adversity. 1999, pounding on the table, I felt bad. I got a little emotional during my closing, putting myself in the shoes of Stan Sr. and what it would feel like, as well as Stan Jr., to have your older brother who runs this business screaming at you in front of your other brothers and your niece and other people that were at the meeting to get out. And that is a conversation that didn't happen once, but according to Frank's daughter, Shelley, who's now the president of SRI, it happened repeatedly. So
it's your position that Stan Jr. has 20 years of continuous adverse use that he need not tack on to his dad?
100%. 100%. And, Your Honor, there are plenty of opportunities for them to interrupt that adverse use, and they just did not do it. They don't even argue that they did it.
Anything else?
I just have a few more. You sound parched, though. Do you want to get a drink? You don't have to, but
Your Honor, I will.
while you're drinking, I will ask you, let's just say for a moment we are looking at Stan Sr. Humor me. Would his, and let's just say for a moment that the issue of the mortgages was before us, was his agreeing to the mortgages, executing the mortgages, did that pause his adversity?
Not based on existing law, Your Honor. There's no law I can point to, there's no case that says,
But the
I don't mean to
theory-
say it's irrelevant. I get that it's relevant. It goes to adversity. It's just not dispositive.
Okay, and are you saying that Junior, the party who is before us, there's no evidence he was aware of the mortgages, or?
There was testimony where he was aware that his father had, was doing things with the company, but not about the mortgages, no. I think he knew that his dad was paying some bills, but they did they did the repairs together.
Junior's names, the party in this case, aren't on any of the documents?
No, and, Your Honor, those are four separate, not contiguous parcels of land, one of which is the property that was at issue at trial, and then the judge cut up that property further to say, this is the part that you adversely possessed, but then the rest of it, not as much. So he was careful. He really carved it up.
So how much weight do you think we should give the acknowledgement that SRI owns the properties?
Well, Your Honors, clear error would have to be the finding of this court to overturn the factual determination by the land court. And so it's not clear error as long as that finding in light of the facts is plausible. Even if Your Honors would reach a different result, the law is that this court doesn't overturn findings of fact. Absence clear error is not present if it's plausible that the judge made the right factual determination, putting aside the, dispositive legal issues.
So does that mean we should give it very little weight? How much weight should we give his acknowledgement that SRI owned the property?
So I think you put it into the pot. Maybe you give it a little bit more weight than other, but I can't, if I'm just trying to be honest with the court, I can't figure out how you give it enough weight to make the land court's decision implausible.
Okay.
I guess that's what I mean to say. It's probably their single best fact, so you definitely want to give it thought, yeah, he did that. At the same time, there's a whole breadth of fiduciary case law showing fiduciaries breaching their duties, and that's what fiduciaries sometimes breach their duties. And so he's signing this thing because the business needs money. It relates to 4 properties, one of which in his mind is his, and Stan's mind is his. You give it weight. I just don't see how it's enough weight to make Judge Vey's decision implausible.
You have a few others? Thank you kindly. The matter stands submitted.
Your Honors, I forgot to mention something. We got right into it. I do have a...
Sorry, that's your time.
What's that?
I'm sorry, that's your time.
Oh, okay, sorry.
That concludes our business for the morning. Court is in recess.
Court is now in recess. Counselor?